Good morning, Mr. Bailey.
Good morning, Ron.
Mr. Norris, this is a status of council hearing, so you're in on Mr. Bailey's case.
Yes,
Your
Joe.
thoughts in moving forward, sir.
We're prepared to make an admission today.
Okay. When we first started talking about the PTR, Mr. Bailey, we told you had a right to have a lawyer. You got Mr. Norris. We told you had a right to have a hearing in which you could contest the allegations, and the state would have to prove those allegations to the court by a preponderance of the evidence. Remember that?
Yes, sir.
If you elect to make an admission today, you'd be waiving that right to hearing. Do you understand that?
Yes, sir.
Is that what you want to do today, sir?
Yes, sir.
To the best of your ability, raise your right hand. You promise to tell the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
Okay. Mr. Norris, factual, please, sir.
Yes, Mr. Bailey, I know the judge looked a lot different back then, but were you placed on probation in this court? Okay. And as a part of those probation rules and terms, you were to commit no new offenses. Is that accurate?
Yes, no worries.
And you did in fact commit a new offense in Elkhart County. Is that accurate?
Unfortunately, yes, I did.
Okay. And that's something that you had pled guilty to and you have served that sentence at this point. Is that accurate?
Yes, I did.
Okay. And also prior to that case, you also had a positive urine screen for drugs. Is that accurate?
Yes, I did.
Okay. I believe that's a sufficient factual basis, Your Honor.
Is the state satisfied?
Yes, Your Honor.
Based on your admissions and our talk about your rights, and the fact that you freely, knowingly, intelligently, voluntarily waived your right to hearing and made an admission that provides a factual basis for the violations. So that puts us in this position now to be ready to move towards a sentencing. What are your thoughts on that, Mr. Norris?
Your Honor, I'd love to move on to sentencing today if the court would hear that. You know, I don't know how the state feels about that, but I'd like to do sentencing today. Probation, were it to have ran its entirety, would have ended June 26th of 26. So I'd just like to have Mr. Bailey's case heard as soon as possible.
State, any thoughts? Do you need any additional information to make a cogent sentencing argument today, sir?
Well, first and foremost, my concern is having accurate critical time for him. Give me 5 minutes and we'll be able to go.
Okay. Just give the state a moment here.
I can also Mr. Norris have that room.
I think to help the state out, I think he's been here since June 12th. The argument that I'd like to make, Your Honor, is pretty simple for Mr. Bailey. I know that we've got that new offense, and one of the things and one of the reasons that we didn't enter admission to the failure to get the classes done is because I think that was because of Mr. Bailey's incarceration. He's basically been in Elkhart for 6 months. He's been transferred back here. He was not released from there. What I would ask, Your Honor, is Mr. Bailey is at this point, he's got a partner who is going to be undergoing some very serious surgery. She's going to have a permanent colostomy bag as a part of it. And he knows that he needs to step up and be a caretaker in that situation. A lot of times this close to the end of probation, I would ask the court to consider, a time served and release from probation. However, in this given case, I don't want it to seem like Mr. Bailey is getting a benefit for receiving that conviction the last 6 months of his sentence. And I do think that there's some good that probation can still do here. He was willing and able to take those classes. I think that there was the one positive drug screen, and then there's the conviction right after. And I know that is ringing a bell in Mr. Bailey's head. There's never a conviction without drug use in his life, and that has been a theme, and that has been something that he's been trying to wrangle his whole life. And I would still like to see him have the benefit of probation, have whatever time told that he's been since the violation was filed, just to give him a head start. I know he's clean and I know he's sober. He's been incarcerated for between 6 and 7 months now. I just like to give him some tools to help address his addictions while he's able to focus on being a caretaker as well.
Thank you, Mr. Norris. State, have you got your thoughts together, sir?
Yes, Your Honor. First and foremost, it looks like he has 25 fresh days credits. They allotted him 134 actual days at time of sentencing toward a total 30-month sentence. He had an initial 18-month executed sentence followed by 12 months spent to probation. Your Honor, this was originally a domestic case. He pled guilty in Elkhart County to a felony domestic case. I think the gentleman had a shot, and evidently it did not go as planned. I believe executing the balance of that sentence would be appropriate given the nature of the violation.
Okay, Mr. Bailey, anything you want to say, sir?
Sir, I want to show this court in St. Joe County that I can complete my probation at least once on this record. I want to show, and I was halfway through it. I was committed into my classes. I was taking my IOPs, and yes, you're right. I slipped up and I had a failure on drugs. I was taking my classes. I was going to my meetings. Like I said, that's the only reason why I wasn't making my class. I want to continue and do what I need to do, and just get the avenues that I need done. Like my wife is going through a surgery here this Monday, and it's pretty serious. I'd like to be there for her if I could, and first and foremost, I just want to show that I can complete this, and just because I had to slip up, and what happened out there in Elkhart, I did the time on it, I got it done, got it behind me, and I'm here now. I want to put this in front of me and get it done if I could, sir.
I hear what you want.
I can complete this probation, sir.
You might. I'm looking at a guy who took on the role of being provider and a protector for somebody. And you have abdicated that role at least twice. Turned around to be an agent of harm on the person you've sworn and agreed to protect. That is an abject failure in your role as a husband and a man. And for her condition now to be your basis for asking for some mercy here,
May I say something, sir?
I don't think you should. I don't think you should at all. It's causing me dissonance in my brain.
Might I say one thing, Judge?
Mr. Norris, go ahead, sir.
Judge, this is for your benefit and the state's benefit. The factual basis and the probable cause affidavit in this particular case that we're talking of was a struggle. We really dove deep and thought about a self-defense argument, but this was a unique relationship because it was polyamorous and there was two alleged victims here, and I think that there was hitting back and forth, but I told James at the time, self-defense is going to be incredibly difficult when there's only three people in the room and two of them are saying that you're the problem. So I just wanted the court to be aware of that. I don't know if it'll make any difference in your decision, but I just wanted the court to have a little bit of a factual sense of what occurred in this case.
Okay, thank you, Mr. Norris. State, do you have anything to add based on that?
If that's the case, Your Honor, it's an additional partner to care for to break that promise and to harm. Additionally, he does also have another conviction for domestic battery out of Elkhart County back in 2010.
All right. Balance of your sentence being opposed. You painted me into a corner. I can't believe it can last since Bailey. I'm sorry. I wish it were otherwise. And I feel bad for spouse, but at this point, the balancing machine is posed. You'll have, you say counted 25 days, I counted 31. See if we can. We'll order a credit time report because it's not of the essence of this moment, but we'll make sure that you do get credit for all the time that you served, Mr. Bailey. Hopefully your takeaway, sir, is that you just cannot anymore, okay? Mr. Norris makes a compelling argument, which is why I hesitated at all. Otherwise, it was just gonna be, he made it harder on me, I guess, is what I'm saying, but, I wish you the best, but you gotta know that there's a line and these acts cross it and there's a price to be paid, sir. Sorry. Thank you.
Your Honor,
Ma'am,
just as a reminder, no contact order is still in place. I'm
Okay.
not sure.
if that's something to be addressed by the parties in a later date, then we'll do it, but
I don't, just as a reminder, just the, no contact or, and the, so there was already an initial 18 months, sir, so this is the 12 months that's being imposed, is that
right,
right?
and he's got some credit time towards that, whether it be 25 or 31 or something, but we'll get that credit time report and then we'll add that in later.
So it'll be about final. So,
Okay, so
Back in from our reboot earlier. This is 64D022004 DN 2898. Linda Pappas versus Nicholas Pappas. I have Tara Tauber here with the petitioner Linda. We're set today on a, is it enforcing an order of some sort? Enforcing a settlement? What are we doing?
Judge,
Can you have the microphone, pull it towards yourself more?
yeah, can you hear me better?
Yeah, thank you.
Judge, just to give you some background on the case, there was an arbitration award in their dissolution matter. I believe in, at least it was accepted by this court in December of 2024. That was prior to my representation of Linda Pappas. That arbitration award provided a money judgment for equalization of the marital estate that my client was to be paid in the amount of $304,042.50. And so thereafter, I believe there were some proceedings. I think Linda Pappas's then counsel filed a petition for rule to show cause or citation or something. And so there was a hearing held, I believe, in March of 2025. There was some briefing. And then it was determined that because this was a money judgment, the appropriate vehicle to obtain funds for Ms. Pappas would be through a proceeding supplemental. At that point in time, or shortly thereafter, she changed counsel and I became involved in the case. We held a pro sup hearing, I believe, in July. Your Honor, I believe you were out and there was a pro tem. And really, Mr. Pappas indicated that he didn't have any money, he didn't have any funds to pay it, et cetera, et cetera. We then attempted to conduct some non-party discovery to see whether or not that was the case. And one of the places that we sent non-party subpoena to was Edward Jones, because Mr. Pappas at one time had not only an IRA there, but some other accounts. Apparently, Edward Jones then, because they received the non-party discovery, they froze, I guess, they internally froze Mr. Pappas's IRA. And so he filed a motion to release those IRA funds held by Edward Jones. And we filed an objection to that based upon the fact that we have discovered that Mr. Pappas has engaged in essentially a systematic attempt to hide his assets that we have discovered through our non-party discovery. And he's lied to the court under oath as to where his assets are. And so we believe that an equitable way to resolve this case wouldn't resolve it, but at least it would help, would be to, for the court to order that those IRA funds be quadroed to my client to at least somewhat give her an equitable resolution.
You need a quadro in an IRA?
Sometimes you do. Maybe Edward Jones wouldn't need one. I don't know. But I know I've had to do them in some cases.
Your Honor, could we
Hold on,
increase the
let's just
volume,
getting
please?
Procedural posture from counsel here, so. Oh, you need a hearing assistance?
I have a severe hearing disorder.
Okay, we can help with that.
Thank you.
This is your volume.
Hmm?
This little knob right here is your volume.
Okay,
Can you hear me?
yes.
Okay. You can turn the volume.
Can you hear us okay?
Yes, I can hear you, Your Honor. Can I make a statement?
In just a moment. But first, I want to find out whether you would like to present any evidence. Or is this just a hearing on turnover?
Well, it is Mr. Pappas's motion
Okay,
that we've objected to. So I think technically it would be Mr. Pappas.
I understand. So really, we're dealing with the February 25th, 2026 motion to release IRA funds and your objection.
Correct.
And that is subsequent to or on the heels of the frozen accounts. Are they still frozen?
Yes,
Okay, sir, please raise your hand to be sworn. Sit.
I have a broken back, I'm sorry.
You could have sat. Do you swear or affirm under penalty of perjury to tell the whole truth and nothing but the truth?
Yes, sir.
Okay, thank you. You can testify from there as well. Can you see him okay? Okay. So, Mr. Pappas, I've got your motion. Did you want to present any evidence related to your motion?
Well, here's the latest summary from Edward Jones.
Okay. Did you want to have that marked and put into evidence?
Yes,
Okay. So I do need you to get up for that. Have you shared it with counsel? Stop by the table there. Let her see it. You
where do I put this?
can put it around your neck, I think. Is it big enough? Probably fairly cumbersome.
Yeah,
And then,
there's quite a bit that I think that the court and Your Honor should be made aware of.
well, sir, let's handle one thing at a time. I've got your document here. Ms. Tauber's had a chance to review it. Would you like to pose an objection at all? I know it's hearsay, but
No objection, Judge.
okay. So let's get that marked. If you could walk it over to my court reporter, she's happy to mark it for you. He is technically the respondent. He's the movant here, but we'll call it respondents 1. And then stop by me and I'll take a copy of it and you can have a seat back at the table, sir. Over here. Okay, go ahead and have a seat at the table. Your letter to me would most assuredly be hearsay, and it would be amplified by the fact that you're actually here and could just testify about whatever it is you would read to me from a letter. So go ahead and have a seat back at council table.
I assume Your Honor knows that my attorney withdrew from the case.
One housekeeping thing before you testify, sir, is that I will admit respondent's exhibit number 1. It's admitted into evidence. What else would you like to say, sir? You can sit if you like. You can stand if you like. That's fine with me. And yes, I'm aware that your attorney withdrew.
Well, can you hear me?
I've got you fine.
Well, after $100,000 of retainers, I told Mr. Rame that enough's enough. I'm done paying this money. And the last 2 years, I hadn't talked to him but maybe 4 times because he had several surgeries. And when I told him I can't afford you anymore, when he told me when I retained him, this may get up to $10,000. And through a mutual friend, the mutual friend told me that he would not be charging you any more money for this divorce proceedings. He denies this now. So I guess I must have made it up.
Objection, Your Honor, as to relevance.
Yeah, so you're into a realm that isn't really relevant to today's proceedings. What we're into from your motion is your request that the funds from your IRA be unfrozen and released.
Yes,
So
my
we're into
attorney,
this is a post-judgment question
yes, sir.
of proceeding supplemental to execution of the judgment.
Yes, sir.
But your attorney your former attorney has nothing to do with it as far as I know. It would have no bearing on this question whatsoever.
Well, what do I do? Don't you take your attorney's advice? He told me they could not, many times, they could not take your IRA. Even O.J. Simpson was allowed to keep his retirement funds. And then when I went to remove it from Edward Jones, they said there was a block on it. That apparently counsel here must have had something to do with that. I don't know, because my attorney did not tell me. All I did was find out through my accountant that the IRA, I was not allowed to know how much was in there. I was not allowed to remove it, even though there's nothing in the paper that I've given the court that says that. And all the monies in that IRA were contributed before I met Mrs. Pappas 20-some years ago.
So I understand, sir. So it sounds to me like what you're doing is attempting to assert an exemption to execution of the IRA. I want to read your motion. When I hear what you're saying, what your lawyer advised you about really doesn't come into play because the law is the law. What I have to do is look into the law a little further, I suppose. I've got the documents here which tell me this is a traditional IRA. The fact that the money was in there prior to your marriage has nothing to do with it at this point because this is an asset that you own and there's a judgment against you. So anything that is an asset that is proper for execution is something they could seize and use towards the judgment.
Well,
So the question for me is whether or not an exemption applies.
yes, sir. Well, I have to prove when he withdrew from the case, he gave me 5 boxes of evidence that he never presented to the court.
Mm-hmm.
And
There was no need to present evidence in your case, sir. It went to binding arbitration and there was a ruling from an arbitrator on the case. And other parts of it were mediated.
these weren't presented to the mediator. There was 2 mediations, sir.
I recall, yes.
And the mediator all she could do is say glowing things about my ex-wife.
Well,
And
sir,
I said, this is a joke.
well, sir, that has nothing to do with this either. So we're really trying to get down to the brass tacks of whether or not an exemption applies. Do you have any other evidence you want to present to the court about the status of the IRA or the possible exempt status of the IRA, anything of that nature, sir?
I was told that, well, if you don't like this ruling by Mark
Coleman,
you could appeal, which I went to her office. She said there was only one in Northwest Indiana. And Dubovich, I believe her name was. And she said, well, it's going to be $25,000 to appeal this case for 1 day of writing.
yeah, I understand, sir. But again, it's irrelevant to the court whether or not you could have appealed and didn't appeal and how much that appeal might have cost you. You know, certainly I understand your plight, but it's just not something that has any bearing on this post-judgment proceeding supplemental execution case that we're here considering today. So if you don't have any evidence related to the exemption, then I need to move on, all right?
What about evidence that was never presented that proves that my wife lied about some serious things during the trial?
This isn't the forum for that either, sir. So if you want to try to go back and undo the judgment somehow, you'll have to get a lawyer or figure out how to do that yourself. But all that we're here for today is proceeding supplemental execution. So you understand procedurally where we're at. There's a judgment that's in place. It's my understanding it's for $304,042.50. That's what's called an equalization payment. That means that when the estate was determined by the arbitrator, they found that to make things equal, whatever the split was it a 50-50?
I believe it was.
Okay, well, there was a 50-50 split that it would take you to pay $304,042.50 back to Linda just so things were even as far as the
But they
distribution
weren't,
of the estate.
sir.
But regardless of that, that judgment's final. Everything that happened leading up to that judgment is what we call merged into that judgment. And I can't revisit any of it, especially without a proper motion before me. So the only motion I have to consider today is you asking for your account to be unfrozen at the AG or at Edward Jones. And all I'm doing is suggesting to you that what you are asserting, I believe, is that it's exempt and can't be executed against. So if you don't have any evidence about it, I need to move on, sir. I only have a half hour dedicated to this hearing. We have another meeting at 4:00 with some other folks.
This wasn't mine. I did not approve of him doing this.
I'm not sure what you mean. I don't know who him is. I don't know what the thing is that you didn't approve of.
I wanted him to write a letter to Edward
Who's
Jones, my previous attorney.
Okay. So irrespective of what you wanted, that didn't happen. Things got to judgment. Everything that happened before is now merged into that judgment. Here we are at the proceeding supplemental to execution of that judgment, the post-judgment proceedings. And last time I'm going to ask you, do you have any evidence that you want to present related to the execution of this Edward Jones account?
So that's all we can deal with today.
So that's the only thing before me today.
I wrote a letter to you.
Okay.
I don't type, so I wrote it. I cursive.
Okay, you're here. So if you want to tell me what's in that letter, I'm fine to listen to it if it's relevant to today's proceedings. But I'm not going to take a letter from you into evidence if it's not pertinent to the case today, which only deals with your exemption. We try to run a very tight ship here, Mr. Pappas. I'm sure you understand. We only have a certain amount of time to devote to every case. And in your situation, I've got 30 minutes. You've burned 20 of them already. I mean, we'll say that counsel spent 10. But I need to get to her to see if she needs to tell me anything or present any evidence of her own, or whether she has any questions for you right now. because you're under oath and she's, I think, prepared to cross-examine you. Is that right, counsel?
Yes, Judge.
Okay. So have a seat, sir. She's going to
I
cross-examine you.
have, evidence that proves that she perjured herself.
Doesn't matter to me today because you have to file a motion with the court. I'm not going to tell you how to practice law. I'm going to advise you to hire a lawyer or consult with one if you believe that that's true. But you have remedies. Some of them are gone, but you have some that may still exist.
The money is gone.
I can't help you with that either, sir.
And I need money to live on. 25 years ago when I met her, I had a thriving veterinary practice that won a national award. We got married and she insisted on paying all the bills, which was fine with me. I put her name on all my assets.
Again, sir, nothing you're telling me right now is relevant in any way, shape, or form. It sounds like you may also try to argue that you've got a hardship, a significant hardship, and that because of that, I shouldn't execute on this Edward Jones account. But in any event, that's part of what I'll consider then when I'm considering your motion, okay? Whether there's a hardship that exists. But I need for you to have a seat, and Ms. Tauber's going to want to cross-examine you. Please sit down.
I have,
Sir, please sit down. She's going to cross-examine you at this time.
okay. I'm sorry.
It's okay. Ma'am?
Sir. I've got some things to mark. Should I have?
Yeah, you can mark them. Yeah, you'll be respondent, and we just use numbers, so petitioner, I apologize, thank you. Yep.
I'm not an attorney, so if you could help me, let me know when I can respond.
Yes, sir. I would notify you, though, that you're here representing yourself, and that because you're here representing yourself, you're subject to the same, sorry, my court reporter is going to want to type.
Yeah, I know the old idiom.
Hold on, I just need to notify him. Sir, you're here representing yourself pro se, which means without a lawyer. So because of that, you're held to the same standard a lawyer is, right? So if you do a bad job today, you can't complain about that, right? You're representing yourself. All right?
I have no choice.
I understand, sir. Ma'am?
Sir, I'm going to show you what's been marked as Petitioner's Exhibit 1. Do you recognize that?
I don't know.
Does it have your name in the corner, sir?
It has my name in the corner.
Do you bank at Fifth Third Bank, or have you in the past?
I'm sorry?
Do you bank at Fifth Third Bank?
Yes, I do. To the extent that that's where my Social Security checks go.
Okay. Do you see, sir, that on January 10th, this indicates that you made a deposit in the amount of $294,365.98 into this account from your Edward Jones investment account. You see that?
I see what you pointed out to me.
Did you make that deposit, sir?
I don't know. Your Honor, I had
Ma'am, or sir, it's not the time for you to argue or talk to me. She's asking you questions. So if you can answer the question as best you can. If your answer is I don't know, then that's acceptable.
Judge, I moved to admit petitioners.
Can I speak to you or
No.
no?
You can ask, you can answer whether or not you object to that document being admitted into evidence.
Yes, I do.
What's your objection?
Because it does not, I have no memory of it. I have
Do you have a business records
I
affidavit?
have memory loss.
Don't have.
That's your problem. It's hearsay.
I have memory loss from 2 crushed skull.
Sir, I understand, but I need to keep this moving. I can't admit that anyway because it's hearsay and there's no business records affidavit. So I need to keep it, but I'm not going to admit it. Yeah. Even though he doesn't know what hearsay is or know how to object to it, I still can't consider evidence that wouldn't be admissible.
You can understand why I said that, because retrograde amnesia.
I wish you could understand why I said what I said, but I need you to hand that back to counsel so she can bring it up to me. I won't consider it during today's hearing. And then if you want to, we could reschedule maybe, and I still need it. Yeah, because I didn't admit it. But
I just don't.
Without,
yeah, you need to get business records affidavits and such like that. Yeah,
I didn't have them with me.
yeah.
without the understanding of the retrograde amnesia that I'm suffering from a neurologist and a psychiatrist.
Sir, please. Have you done holds on bank accounts as well?
No, because Mr. Pappas stays ahead of me in my discovery. So every time I send a non-party request, he's already moved the money to a different bank. And so then by the time I go to that bank with it, he's moved the money again.
Okay.
And so this is what's happening. And now there's funds in an Illinois bank, so they're not going to be responsive to any of my subpoenas unless something's domesticated over there. And I'd actually subpoenaed the bank statements from the Illinois bank where I believe $200,000 is sitting.
And you know what bank it is?
Yes, I do.
Why don't you just do a pro-sup on it?
Because it's Illinois, so they're not going to respond to it.
They are.
You think so?
Hey, Mr. Pappas, let's do a quick proceeding supplemental hearing, okay? Just to keep this proceeding supplemental going for the court. Do you own any real estate anywhere, sir?
I'm sorry?
Do you own any real estate anywhere in the world?
No.
Did the headphones stop working?
I'm having trouble with it.
Your headphones, sir. You need to put them up over your ears.
Do they not work anymore?
Go ahead, please.
Okay, do you own any real estate anywhere in the world, sir?
I can't, I'm not hearing. And I have this all the way turned up.
Okay, come up here. I don't know. You can take the whole thing away from them. Can you hear me now? What about now? Have a seat. All right, sir. Do you own any real estate anywhere in the world?
I'm sorry?
Do you own any real estate anywhere in the world?
No.
Okay. Do you own any motor vehicles?
I have a lease vehicle.
Okay, so you don't own any vehicles.
No.
All right. Do you have any savings in any bank accounts?
Only the one where my social security check goes.
And what bank is that?
Fifth Third.
And your social security money is deposited there?
That's correct, sir.
Okay. Do you have any bank accounts in Illinois?
No.
All right. Do you have any other retirement accounts aside from this Edward Jones account?
No, sir. All I want to do is live. I That,
Any big ticket property items, any holdings with gold, anything of that nature?
no, those were embezzled by my wife.
Do you have any positions in the stock market whatsoever?
None,
Any futures positions?
none.
Okay.
Only one being the IRA.
Any other investment accounts of any kind?
None,
No stocks,
none,
no bonds?
none.
Okay. Any other questions you want to ask them?
Did you deposit money in 2025 in the First National Bank of Illinois?
Not to my recollection.
Okay, I'll continue this. I've got time a week from Thursday on the 16th. I don't know what your calendar looks like, council.
Are you talking to me or
What?
the
In the afternoon, Judge, or the morning?
Either one.
I could do the morning.
I could be ready by 9:30.
Your Honor,
I don't
I
think that works.
can't because
Mr. Pappas, do you have any availability next Thursday, the 16th?
no,
What's your situation?
because I'm going to Sloan Kettering for further cancer treatment.
How long have you had that appointment?
The appointment was just made a week or two ago.
Okay, and your appointment's on the
through
16th?
a urologist.
Your appointment's on the 16th?
I don't remember if that's the exact day, no.
Sir, how can you say you're unavailable for something because you have an appointment and yet not know when the appointment's actually scheduled?
Because they want me at the spur of the moment. They only have so many openings.
Okay, well, you tell them that the 9:30 opening on July 16th is unavailable because you have to be in court. All right? And I'll see you back at 9:30 a.m. on July the 16th. You're ordered to appear. And if you don't appear, I'll issue a bench warrant for your arrest. Okay? We're adjourned.
Is that,
Morning, jail. Can you hear us okay?
Your Honor, yes, we can.
Thank you, sir. Letting people go. Anthony Blackman, state would you please set a record?
State of Indiana versus Anthony Blackman, 60-01-24-12-5-13224. Defendant is present by video at court, and by counsel attorney Clements. The state is represented by Deputy Prosecutor Hammer. We were set today for bond review.
Good morning, Mr. Blackman. Can you hear us okay?
Yes, sir.
Morning, sir. Would you like to present your petition for bond? Reinstating bond, it looks like.
Yes, sir. I also filed the plea agreement. I thought we'd skip right to that. If that's.
That'd be a great idea. It hasn't populated yet in my system, though. Let me refresh here and see if that.
I filed it on, I don't know, Saturday. I've got a copy of it if you want it.
You gonna try to dig for it, or just want me to do physical? Yeah, let me just get a physical copy of it if you want to approach with that, Mr. Clint.
Okay. Problem is, it's my only copy.
Well, I can burn one.
Okay. Well, I don't want to sign.
I got a photocopier.
Yep.
Not fast or anything, but it makes copies. See you there, hot off the press. Mr. Blackman, for purposes of the change of plea, please raise your right hand to be sworn. Your other right. Do you swear or affirm under penalty of perjury to tell the whole truth and nothing but the truth?
Yes, sir.
Thank you. Sir, please state your full name for the record.
Anthony Montel Blackman?
And have you ever used any other name?
No, sir.
How old are you, sir?
28?
Show your birthday as August 28th of 1998. Is that right?
Yes, sir.
My math says you're 27.
1998. I turned 28 in August.
You will be 28 in August, correct?
Yes, sir.
You're 27 as you sit here before me today. Correct?
Yes, sir.
These questions are really going to get tougher, Mr. Blackman, as we go. All right?
Yes, sir.
All right. Court has been informed that you wish to change your plea to guilty on count 2, domestic battery, a class A misdemeanor. Is that correct?
Yes, sir.
Before I can accept any guilty plea, I need to ask you some questions. Anytime you don't understand a question, let me know and I'll explain. Anytime you'd like to speak with your attorney before answering, let me know and you'll be permitted to do that. Have you ever been treated for any mental illness, or do you now suffer from any mental or emotional disability?
No, sir.
Are you currently under the influence of any alcohol or drugs?
No, sir.
To count 2, domestic battery, a class A misdemeanor, how do you now plead?
As the paper say, guilty.
Well, sir, I need for you to say it.
Guilty.
All right, sir. Mr. Blackman, you have the right to a public and speedy trial by jury. Do you understand that?
Yes, sir.
You have the right to face all witnesses against you to see, hear, question, and cross-examine those witnesses. Do you understand that?
Yes, sir.
You have the right to require witnesses to be present at any hearing or trial to testify on your behalf, and the court will assist you in exercising that right by issuing subpoenas. Do you understand that?
Yes, sir.
State of Indiana must prove beyond a reasonable doubt that you committed the offense charged before you could be found guilty of that offense. Do you understand that?
Yes, sir.
You cannot be forced to make any statement or to testify against yourself at any hearing or trial, but have the right to remain silent. Do you understand that?
Yes, sir.
If you were to have a trial and were found guilty, you would have the right to appeal your conviction to the Indiana Court of Appeals. Do you understand that?
Yes, sir.
By pleading guilty, you're giving up all of the rights that I've just gone through. Do you understand that?
Yes, sir.
You have the right to be represented by an attorney at all times, including trial and appeal. If you cannot afford to pay for an attorney now or at any future time, the court would appoint one for you. Do you understand that?
Yes, sir.
By pleading guilty, you're admitting that everything the state would have to prove beyond a reasonable doubt for you to be found guilty is in fact true. Do you understand that?
Yes, sir.
By your pleading guilty, the court will proceed with judgment of conviction and sentencing without a trial being held. Do you understand that?
Yes, sir.
If you're not a citizen of the United States, a conviction of these charges may change your immigration status. You might either be in a less favorable immigration status or subjected to being deported from the United States. You think that'll be a problem for you in this case?
No, sir.
A possible penalty for a Class A misdemeanor is up to a year in jail and up to a $5,000 fine. You understand that possible penalty?
Yes, sir.
Do you have any previous criminal convictions or previous juvenile delinquent adjudications? Those may cause an increase in your sentence, or they may prevent the court from suspending part of your sentence. Do you understand that?
Yes, sir.
Are you currently on parole or probation anywhere?
Oh, no, sir.
Other than the bond you posted here, are you out on bond on any charges anywhere?
No, sir.
Lake County.
You do have a Lake County case?
Yes, sir.
Only reason I ask is it might cause a revocation of your bond. I'm sure Mr. Clements advised you about that. And this plea of guilty may cause harsher sentences for any future crimes. Do you understand that?
Yes, sir.
The court received a 4-page document entitled Recommendation of Plea Negotiation. The document appears to bear your signature about halfway down on the 4th page. Did you sign this agreement?
Yes, sir.
Did you read it before you signed it?
Yes, sir.
Did you have a chance to speak with your attorney before you signed it?
Yes, sir.
Before you signed this, do you believe you understood its contents completely?
Yes, sir.
As I understand the sentencing portion of the agreement, count one would be dismissed and you would be sentenced to 360 days in the Porter County Jail, all suspended. You'll spend the balance on formal probation. You'll undergo anger management or mental health treatment as a condition of probation. Be responsible for the payment of all associated fees. You'll sign all releases of information for the court, probation, state, and council. You'll pay the criminal offense mandatory fee, which is a $50 domestic violence prevention and treatment fee. There's a no contact order that was entered as a condition of bond that'll be terminated at the time of sentencing. And I think in this case, we'd have to have a domestic violence determination as well. Is that right?
I believe so, Your Honor.
Okay. Is that your understanding of the sentence?
Yes, sir. Judge Fitz, I got a statement.
Say it again, sir.
I have a statement.
Okay, well, you don't need to make a statement quite yet. I've got a few more things I need to get through with you.
Yes, sir.
Okay. All right. Do you understand that you'll get credit for your time served awaiting disposition of these charges?
Yes, sir.
Do you realize I'm not a party to this agreement, but if I choose to accept it, I'll be bound by its terms at your sentencing and with respect to any future sentence modification?
Yes, sir.
Have you or anyone else received any promises or been given anything of value to cause you to enter this plea of guilty?
No, sir.
Has anyone forced or threatened or placed you or anyone else in fear to cause you to enter this plea of guilty?
No, sir.
Okay, your attorney is going to ask you some questions. Are you prepared to set the factual basis?
Yes, sir.
Your attorney is going to ask you some questions to establish what we call a factual basis for your case. Please give him your attention.
We're going to turn your attention to December 23rd, 2024. You were in Lake Station, Indiana, correct?
Yes, sir.
And you were with a female by the name of Brittany Hernandez.
Yes, sir.
You were in some sort of relationship with her?
Yes, sir.
All right. And while you were in Lake Station, Indiana, an incident between you and her occurred, correct?
Yes, sir.
All right. And then at some point before the police arrived, the two of you left the place in Lake Station where you were, correct?
Yes, sir.
You were at the Flying J truck stop there in Lake Station?
Yes, sir.
All right. And then you drove into Porter County, you crossed the county line road, correct?
Yes, sir.
All right. And then whatever the altercation was between you and Ms. Hernandez continued as you were driving into Porter County, correct?
Yes, sir.
All right. And then at some point you let her out of the car?
Yes, sir.
Okay. And when you did, you ended up getting stopped on Willow Creek and Route 6 in Portage, correct?
Yes, sir. Yes, sir.
All right. And then Ms. Hernandez got picked up by some Portage police officers, correct?
Yes, sir.
So you committed what we call domestic battery by having some sort of rude contact with Ms. Hernandez, all in violation of Indiana state law, correct?
Yes, sir.
All right. And all those events took place in Porter County, Indiana. I know there were events in Lake County, but there were also events in Porter County. Those are the only ones we're interested in right now. So you had an altercation with Hernandez before you let her out of the car in Porter County, Indiana, correct?
It was in Lake County. The police picked me up in Porter County.
I know where they picked you up, but
Yes,
there was still an altercation between the two of you that went beyond the county line from Lake County into Porter County.
Yes, sir.
Yeah, and everybody got picked up in Porter County, both Ms. Hernandez and you, correct?
Yes, sir.
All right. But you admit that you had an altercation, you struck Ms. Hernandez while she was still in the car before she exited while in Porter County, Indiana. Correct?
No, sir.
Wait a minute. Well, I guess we got a problem, Judge.
Okay. You don't think you can make the factual basis today?
Well, if we could,
That's what the police had said. If I need to, that's what I'm pleading guilty on.
What's that, sir?
I'm pleading guilty on that, so I should say yes, sir.
you're pleading,
Yeah, sir, but it doesn't work like that. I mean, you either did the battery in Porter County or you didn't do the battery in Porter County. So you've just told your attorney, you've indicated to him that you didn't touch her while you're in Porter County.
I'm just saying yes, sir.
Right, but that's not going to work because you a few minutes ago said no, sir. So we got to come back another day to handle this.
I can't try to clean them up real quick, or you're
Well,
satisfied?
it's tough to do on the same day.
Well, I apologize, Judge. I mean, yes, sir.
I think part of the confusion, Judge, is that neither the victim nor the defendant are from around here.
Sure.
And probably don't have a understanding where the county line is and all that business. That's all I can think of because, we talked about it the other day and he was fine admitting that there was an ongoing altercation that crossed the county line road. I don't know if that would help or you want to come back.
Well, I mean, is there some sort of landmark on Central Avenue and Swanson Road that we can reference?
Well, that's where I don't know that he can reference. That's where he would say he let her out. But then he was not apprehended until he was at Willow Creek and 6. And then she was apprehended near Swanson Road.
Okay.
So again, I'm not sure that he's familiar. It was late at night. I know it says 9:16, but it was or thereafter.
I mean, he's from Crown Point.
Well, that's kind of a new location for him as a truck driver. I don't think he's got a long history in Lake County.
What are you doing next Monday?
Well, I got to be here with you, I think.
Do you?
Galinsky. Did you reset Galinsky to next Monday?
I've got Galinsky. Are you entering on that? I don't have an attorney down yet.
Yeah, well, I've been his attorney for a long time. But yes, I will enter on that one. So,
Okay. Mr. Blackman, are you trying to go back to work if you get out of jail?
Yes, sir. Because can I just restate my statement? Just saying yes, sir, not no, sir, to that question you asked me.
I'll absolutely permit that, but not until next Monday. So what I'm going to do is release you on your previously posted bond, have you come back a week from today at 9 a.m., and we'll give this another go. All right?
I have to say it.
If you fail to appear, I'm going to throw you back in jail.
Yes, sir. Hey, I got something I need to let you know, Mr. Fisher. I apologize for everything. Me pleading guilty to that plea deal that Joe Clement came here last Thursday and provided before me in the room and at me. I already attended that class here. I got the certificate. My teacher sent Joe Clement the completion of certificate for the relationship course for the domestic.
Make sure you bring it with you to court next week. Okay?
Yes, sir.
We'll see you in a week. We'll release you on your previously posted bond. July the 13th at 9 a.m. You're ordered to appear. If you fail to appear, I'll issue a bench warrant for you.
Yes, sir.
He does have an outstanding warrant in Lake County, so I'm not sure he's going to make it back over there. And
I got court tomorrow.
over there?
Yeah, I don't have a warrant. I asked when we left out the meeting, I asked him on
I
the
don't have
intercom.
time to do all this business, Mr. Blackman. We'll transport you over to Lake County if you have something over in Lake County. We'll make sure you get over there for it. I'm gonna give this back to you.
All right, thanks.
We also didn't have a waiver of appearance. Well, you don't, oh, yeah, if he's still in jail, you'll need it signed. Otherwise, if he's out of jail, obviously not. And here's your credit time if you want it. Here's your credit time if you want it. Yeah. Anyway, we'll see you next Monday. Add 7 days, right? We're adjourned on Blackman.
Thanks for trying.
I feel like we gave it a pretty good try. Is Mr. Fife here?
Here, Your Honor.
George Lampa, state, would you please set a record?
This will be State of Indiana versus George Lampa, 604001, 2605 F3, 5034, and 604001, 2605 CM 5330. Defendant appears in custody by video at the Porter County Jail and is represented by counsel, Attorney Fife, state's represented by Deputy Prosecutor Hammer. We're set today. I apologize. We were set today for status omnibus, Your Honor.
Morning, Mr. Lampa. Can you hear us okay?
Yes, I can, Your Honor.
Mr. Fife, how can I help, sir?
Well, Your Honor, I'd also previously filed a request to terminate the no contact order that has been filed in the level 3 case. And I believe the court indicated to set it today. The alleged victim is here to testify.
Okay. You ready for that, state?
Yes, Your Honor. I can be ready for that.
Okay. Is the victim in the room?
She is. Ms. Gomez, would you like her at the witness stand?
Yeah, come on up, ma'am. You stop there and raise your hand to be sworn. You swear or affirm under penalty of perjury to tell the whole truth and nothing but the truth. Thank you. Please be seated. Pull yourself up to that mic.
Ma'am, would you please state your name for the record?
My name is Kristen Gomez,
Could you please spell that as well?
KRISTENGOMEZ.
And ma'am, do you know Mr. Lampa?
Yes,
How long have you known him?
almost 3 years, going on 4.
Okay. And are you currently aware that there's a no contact order prohibiting him from contacting you? Is that a yes?
Yes.
Okay. Do you want that no contact order to remain in place?
No, I want it lifted.
Okay. Do you feel safe if it is lifted?
Yes.
Okay. Is this your request?
Yes, it is.
Has Mr. Lampa asked you to do this?
No.
Okay. And again, you feel entirely safe if it is lifted, correct?
Yes, I do feel safe.
Okay. Do you two have any children together?
No.
Okay. Are there any children living at the house?
No.
And do you typically live with him?
Yes.
Okay. Where is that?
Right now we live in Michigan because we just moved out from Portage, Indiana.
Okay. All right. Judge, I have nothing else.
Okay. State?
Miss Gomez, you are aware that he has been found 3 times with you in violation of said no contact order, correct?
Yes.
And each one of those times you were aware that the no contact order was in effect, correct?
Yes.
And he has actually talked to you about the case at hand without getting into detail, correct?
Yes.
And he did that actually while he was still at the jail, correct?
Yes.
And then after that, when he was released, he then again met with you on and was found at your residence twice over, correct?
Yes.
I have nothing further, Your Honor.
Thank you. Any further questions, sir?
Nothing else, Your Honor.
You can step down, ma'am. Thank you. Further evidence, sir?
No other evidence, just argument.
Go ahead, sir.
Thank you. So, Your Honor, alleged victim is here. She's testified she feels safe. There's no children in the home. They typically live together. She wants it lifted. This is her request, not ours, not Mr. Lampa's. This is entirely her request that she relayed to me. And given that she clearly hasn't had any issues with the no contact order and wants it lifted, that'd be our request as well.
State?
Your Honor, he is showing that he cannot comply with court's orders while being out on release by having 3 separate, and actually one while he was still in custody, Your Honor, still having interaction in blatant disregard for the court's order. And additionally, that the victim has testified that they had talked about the case. So the state's concern is that he's influencing testimony and otherwise in this instance and giving her information that she wouldn't normally either have or otherwise a benefit, Your Honor, and otherwise giving influence to her testimony at any given point in this, Your Honor. And this isn't just one time. This has now been 3 separate times. Again, he's been violating after being advised of it multiple times, Your Honor. And again, with her moving out of state to Michigan, that causes the state even more concern about the likelihood to reoffend and additionally obstructing the judicial process, Your Honor. So state would ask that the no contact order remain.
Okay, yeah. We'll deny your motion to amend the no contact order. At a minimum, the court owes a duty to the legal integrity of the case, and I feel that that is in significant jeopardy here. The state just informed me, and I'm assuming that it's also found in probable cause affidavit. There's information that there was discussion about the case. That subject matter in and of itself, I think, pulls in my judicial canon 1.2 that I need to promote public confidence in the integrity and impartiality of the judiciary. So legal integrity of the case here will ensure that the legal proceedings are conducted fairly and that evidence is presented truthfully and the rule of law is not undermined by criminal interference. So we'll deny that. Anything else, sir?
Judge, the only other thing, based on the new arrests, my client his bond was revoked. I know the court denied the motion for the no contact order, and so I'm assuming the answer is going to be no, but would the court entertain a bond for Mr. Lampa at this time?
You can certainly file a motion for bond.
All right.
Again, we have to have a written motion for bond.
Sure.
Before we'll consider that, it should be filed pursuant to the trial rules at least 5 days before any hearing. Would you like for me to set it over for next week so you can argue that?
Can I look at my calendar real quick?
Sure. You have a hearing on right now that was set for July 26th. I was going to vacate that today. I think that's an initial appearance on a Wednesday, so I don't know that it could work for the bond hearing. Mr. Hammer's looking at me like I'm crazy, getting him up out of bed on a Wednesday morning at 8:30.
July 26th is
It's a
a
Sunday.
Sunday.
Oh, is it really?
Yes.
Well, that must be a
That was more of the weird luck.
pretty good fat finger on whatever was typed up here, but that's all right.
I could do next Friday, Your Honor, 17th.
Yeah, we don't do them on a Friday, so it's got to be Monday.
Monday only?
Yep.
Okay.
You can appear by Zoom if that helps.
That would help.
Where are you coming from?
Indianapolis.
Well, yeah, why don't you appear by Zoom? We'll do a bond hearing, just get a motion on file.
Okay.
What time you want to do it next Monday?
Could we do afternoon?
No?
No?
We only do them in the mornings.
Okay. Well, then, okay.
11 o'clock looks good, though.
That's-
You're noon.
That's perfect.
You have to pack your lunch, man.
That's fine.
All right. 11 a.m., July the 13th. We'll have you back for a bond hearing, unless the motion isn't filed. So get that on file, and we'll look for that. Okay?
And then do I need to file a separate motion to appear by Zoom?
No, I just said you're okay to appear by Zoom.
Okay, there we go.
Yes.
Just want to make sure.
And then, yeah, I have a concern. I'm not sure what I'm supposed to vacate. There was apparently an initial appearance that was set on some future Wednesday that doesn't need to occur now because you're here and Mr. Lampa already knows what court he's in. So, Mr. Lampa, looks like you were supposed to appear some future Wednesday. I'm not sure where or when, but you don't need to appear on any Wednesday morning in the near future. Do you understand?
Yes, Your Honor.
We'll see you back next Monday, and then you also have a pretrial conference on August the 10th that I'll affirm at this time.
Thank you, Judge.
Thank you, sir.
CV 1214, show the plaintiff appeared by council representative, defendant appeared in person. Love, did you have the chance to speak to your client regarding the pre-eviction diversion program on this case?
Yes, I did.
In this case, your client is interested in seeking the pre-eviction diversion program.
Not at this time. No.
All right. Brandon, I can't place the case in pre-eviction diversion status at this time. Is there anything you would like to talk about before we get started? Okay. And I need you to please raise your right hands to be sworn in. Do you each solemnly swear or affirm under penalties for perjury that the testimony you give will be the truth, the whole truth, nothing but the truth? Okay?
Yes.
Thank you, folks. Go ahead and put your hands down. I'm going to give each party the equal opportunity to be heard, but I ask that we not interrupt each other. That is to say, while the plaintiff's presenting evidence, Ms. Brandon, I ask you not to interrupt him. And when you're presenting your side of the story, I'm going to ask that you get the opportunity to present without being interrupted. Okay? So there may be a point where you have a chance to ask questions. There may be a point where the plaintiff's counsel has a chance to ask questions of you. But that'll be after you finish telling me, after you each finish telling me your respective sides of the case. Okay? All right. Ms. Luck, I'll turn to you first. I see there was a lease filed with all our title plans exhibit number 1, and you can go from there.
Wonderful. Thank you, Your Honor. Can you please state your full name for the record?
Jaden Smith?
And are you the property manager at Beacon Heights Apartments?
Yes.
And does the defendant have a lease agreement with Beacon Heights Apartments?
Yes.
Are the terms of that lease agreement from September 6, 2025 to September 5th, 2026?
Yes.
Pursuant to Section 23 of the lease agreement, does it provide that the lease may be terminated by the landlord for a number of reasons, including material noncompliance and potential criminal activity?
Yes.
Pursuant to that lease, is material compliance of the lease include repeat minor violations of the lease that adversely affects the health and safety of any person or the right of any tenant to a quiet enjoyment of the leased premise?
Yes.
Did your office issue a 30-day notice to terminate the lease to the defendant on May 18th, 2026?
Yes.
And what was the reason for this notice?
Friday, April 15th.
And can you explain what this incident involved?
There was a large group of individuals fighting within the parking lot. A couple of neighbors that involved 3 houses. Miss Brandon was there. She was also a part of the fight. There was in the camera footage that we submitted showed all the individuals they were fighting, and there's been disputes going on since April within these households, multiple households, and that's the reason why we're here.
And since the date of this notice, has the defendant continued to engage in conduct that violates the lease agreement and threatens the safety of other tenants?
Yes, there have been additional activities since May.
And can you explain what event took place on June 17th of 2026?
On June 17th, there was another fight out in the parking lot involving a number of individuals, and they were all there gathered and fighting the guests of 3438, and Miss Brandon was there fighting in support of her friends. So
were the police called to the property?
Yes, the police were called to the property, and the officers called me. I was out of town, and they informed me of different windows being busted out at 3438, but she didn't bust out the window, so nothing but stemming from everybody fighting with each other.
Your Honor, I would like to admit, as I believe it's Exhibit 2 in this case, the public summary report from the police station.
Sure, it's 2 admitted.
Do not sure copy the reports.
That doesn't resolve.
Is not you have the email the author since this in Friday before the 4th of July, and the report was new that we received on.
This is for Friday.
Sorry.
July. Sorry.
Sorry, Your Honor, June 17th, that Friday. They haven't been able to submit all of, because there were so many people involved, they haven't received a full police report. This was what we were able to get within that short period of time frame.
Okay.
That's all that they released to me.
And yes, what was released to the client. Due to the incidents that have occurred on this premises and continued violations of the lease agreement, are you seeking immediate possession as of today?
Yes.
And that is all, Your Honor.
Mr. Smith, what evidence do you have to show that Ms. Brandon was actually involved in this altercation?
Well, when we filed, I submitted all the video footage,
Admitted to who?
to the attorney when I filed all the paperwork. When I submitted the paperwork to the attorney's office, we uploaded the videos that were posted on Facebook, our camera footage. Ms. Brandon was identified by camera footage. That's the reason why she received the 30-day notice, because she was out fighting, and when she threw her hands up, she was on her end of the parking lot, and when she moved forward and everybody started fighting, everybody was fighting together. Her and the people at Miss McGinnis' home who just left. So I don't know why.
And this was the most recent fight occurred. The initial fighting also occurred on April 15th of 2026, which was what the initial notice of termination of purchase agreement was sent for. And then the June 17th fight had also occurred.
Is there video of this? Is there pictures?
We do.
You're asking me to kick someone out of their place, and I'm gonna need more than just a police report that has 0 words on it.
I can submit as Exhibit 3 an email that my client received pertaining from the police department regarding the matter. And then I can also admit as Exhibit 4 a flash drive that does contain some images. However, it is dark and it's not clear. And this is the flash drive.
The report that I have on file only notes who complainants are with no suspect information. The officer notes when he arrived on scene, he witnessed people actively trying to hit others while other people yelled at one another and others were pulling people back. What do you have to show that Ms. Brandon was involved in this fight, other than pulling people back? I don't consider pulling people back to be something that would be worthy of removing someone from their apartment.
The fight that occurred in the violence, I provided the footage. I provided all of the footage to the attorney's office, which visibly showed everyone on camera, even the screen record videos that were on Facebook that showed everybody fighting visibly, interrupting the peaceful enjoyment of the community, putting everybody in danger. There have been multiple fights.
Well, let me see what this flash drive might have on. Oh, right the first time. No. I don't know if I'll do sound, but
I think that's the June 17th footage where they were.
oh, sorry, it was on the wrong screen.
That's the footage from June 17th. That's the footage for Maya McKinnon. They should have all the videos from the April 15th. You know.
Smith,
Yes.
do you know who was actually involved in this fight?
So, and what that video footage show, that video is Maya McKinnis, 3438 Curtis Drive, who's
Let's talk about this.
and Ashton.
Let's talk about Miss Brandon.
Miss Brandon is not in that video. That's not the video that I provided for Miss Brandon for the fight that happened on April 15th that I provided to the attorney's office.
But she was involved in this specific incident and
In the June 17th?
I didn't get all the names of everybody. I know everybody was out there, but prior to the June 17th incident, that was the incident involving Ashley Hall and Alexia Manning. I mean, not Alexia Manning, Maya McKinnis were just left. Everything stemmed from, on April 15th, when everybody
Was there a
the
police
third
report from April 15th?
the police officer did not give me a report when they came out.
Okay, from that. What can you show me that tells me, and I know you're telling me that you gave it to your attorney, so Ms. Lund,
We don't.
you're gonna need to come with more than just a blank police report and a photo and a video that has Jack SWAT on it for me to want to kick someone out of their apartment.
Understood, Your Honor. From the notice that we did provide back in April 16th, there was a fight that had occurred on April 15th of 2026. That was initially what it was for. Unfortunately, I do not have the footage with me for that specific fight.
And it may very well be that's accurate. I don't know, but I think that out of fairness, it would be unfair for me to say, well, there's just someone who's reported that a fight happened and I've got a blank police report. For me to say that's enough to find that it is more likely than not that Ms. Brandon or people affirmatively associated with her were engaged in this conduct in violation of a lease. I don't have it from what I have here. I just don't. And I'm more than happy. I agree with you that public safety is a primary importance, whether it's publicly supported housing, whether it's private apartments. I don't disagree with that. But for me to just say someone reported something and there was a big ass brawl and all of a sudden people are getting evicted from their homes or requests are being made to evict people from their homes. I have to have a higher standard than just there were reports made that it's believed that there were people involved. When we talk about rent, we talk about documentation, right? We talk about there's a ledger, we can show proof of payment history and all of this. We don't just take, well, I think that they probably owe me a little bit of money. I don't know how much. I don't have a contract to say exactly how much they owe me something. We require proof of that.
Sure.
And this isn't bashing on anybody. This is just to say this is a very important concept, and that just because there was a fight that Ms. Brandon may or may not have been involved in, the officer said, I don't really know who was involved. There were a bunch of people complaining, and I'm going to need more than that. So I can't find right now that there's been affirmative proof to show that possession should be granted. Mrs. Lund, unless you've got something else. I'm sorry, I don't mean to shortcut it there, but if the entirety of the ask is there was a report for a bunch of people fighting, and this is what you got, it's not enough.
I do have an agreement between Alexis Brandon and my client that was executed March 5th of 2026, which occurred after that initial brawl that happened.
No, it didn't. March 5th.
Sorry, before that pertain to discussions that she was allowed to maintain her current housing status upon certain conditions, which included not allowing one individual onto the property, not causing or participating in any disturbance on the property during the next 30 days, and participation in mandatory mentoring. I will admit this as Exhibit 6.
That would be obvious.
Came from out of the email, the defendant had accepted the terms of that agreement.
Is it Alexis or Alexia? Okay, I'll change that. I'm sorry. It was noted as Alexis on my report. Okay.
Pursuant to that agreement, although, there was the violation that occurred on April 15th, which did involve her in some way, shape, or form participation in a disagreement. And she had also invited that individual onto the property as well.
Says who?
Pursuant to my client's testimony.
It was the testimony. I didn't think the testimony had anybody in particular. Maybe I listed in the slew of no names that were given, but was the Stanica James found to be affirmatively on the property?
So can I shed a little light on why that agreement came into play?
Well, if we're talking about, if this is now, if we're moving to this as the violation of the agreement.
So I don't know what happened with why the extra was not provided to Ms. Love, but everything was provided and confirmed with the attorney's office.
Okay, and I don't doubt, Mr. Smith. I'm not saying, I don't know how, I only know what happens in the end, what comes to me. So anything before that, I'm not passing judgment on. I don't know what was or wasn't, but I guess my question is, Mrs. Love, are you moving now to this, the violation of this agreement as the violation terms? Because that
No, Your Honor.
I guess, so what does this add?
Just to the purpose that there was an additional event that had occurred after that notice. And like you stated, at this time, we do not have any additional proof.
Yeah.
The defendant was involved, so.
There may have been another event that happened after this, but I don't have any information about who was involved and what it was about. I just don't. And listen, I'm all about, I think I said, or I'm all about public safety. I don't hate, people who cause violence, whether that's property damage or personal injury. I don't. But I also have to uphold the idea that there's got to be some proof that the strain was involved, that she allowed, listen, people can come around. If Ms. James was on the property, I don't know if she was or wasn't, it would have to be proven that Ms. Brandon allowed Ms. James off the property. She didn't just come by. It was by invite or by request. There would have to be some proof that she caused or participated in disturbance while I was even within 30 days, so we're not even within that. I can't just rubber stamp an eviction because there was a fight on the property. I'm just not there.
Understood.
So, is there anything else, Mrs. Love?
No, Your Honor.
Okay, at this time, I'm denying the request for immediate possession. So, because the immediate possession request is denied, I'm not sure this case dismissed. Ordered sealed. Granted, I don't know if they will attempt to refile. If they refile and they have sufficient evidence, I can't say that I would consider. But consider what evidence is going to be for time being, go with that. Okay? So if you get a notice that says you need to come back for another court hearing, if they attempt to recover evidence, we might be talking your end of the story. I know I didn't move over to you, but there wasn't even enough respectfully to move over. So all right, so I'll show the case dismissed. Immediate possession, good luck.
Thank you.